Good day everyone, I'm Mary and Dizon. Today we're gonna discuss three topics. First is the remedies of capitalist partners where industrial partner engage in other business. Second is the obligation of capitalist partner to contribute additional capital. And third is the obligation of managing partner who collects debt. So first is the remedies of capitalist partner where a industrial partner engage in other businesses. So yung ano nga ba yung pwedeng gawin ng capitalist partner kapag yung industrial partner is nag-engage in other business. So nasa Article 1789. So an industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of these provisions with the right to damages in either case. So, as we all know that the industrial partner, ang kino-contribute niyan is his industry, yung skills niya, yung or service. By the very nature of that, ang sinasabi lang ng Article 1789 is that an industrial partner cannot engage in other businesses for himself. So, ibig sabihin, yung full attention is sa partnership lang. So, hindi pwede sa ibang partnership or sa ibang business or sa ibang bagay. Ang contribution kasi ng industrial partner, di ba, is not pera or capital. Yung service niya mismo. So, pwede naman siyang mag-venture sa ibang business unless yung partners permits him to do so. So, pero kapag walang permiso, he cannot engage kasi ang contribution niya is service. So, that's labor. So, kung mahihirapan siyang makapokus sa partnership, mismo if magve-venture pa siya in other businesses. So, as much as possible, ang kanya, doon lang siya doon sa partnership niya at hindi na tumitingin pa sa ibang partnerships. So, prohibitions against engaging in business. So, as regards to the industrial partner, ang prohibition dyan is he cannot engage in business unless partnership expressly permits him to do so. So, under Article 1789. So, industrial partner, kahit na same line man niya ng business or kahit ibang business, for example, ang business nila is sa food industry, tapos yung other line of business is clothes. Kapag walang permission or walang permission ng partnership or ng kanyang partners, he cannot engage in that business. Kasi time yung pinag-uusapan dito yung labor. So, dapat nakafocus lang siya sa business ng partnership. So, as to regards naman sa capitalist partners, the capitalist partner cannot engage in business with the same kind of business with the partnership for his own account unless there is a stipulation on the contrary under Article 1808. So, bawal siyang mag-engage in other business as same kind or line with their partnership unless there is a stipulation to the contrary. So, ang purpose kasi nito is parang hindi maging competitor kasi partners ka dito tas mag-engage ka with the same kind of partnership, 'di ba? So, bawal mag-engage yung capitalist partner with the same kind or same line of the business they have. For example, yung industrial partner is pasaway. Nag-engage nga siya sa isang business or without the permission of the other partners. So, anong mangyayari? So, these are the remedies where the industrial partner engage in business. So, first is he or she can be excluded from the partnership. So, pwede siyang tanggalin sa partnership. Hindi na siya magiging partner doon. So, second is, the capitalist partner can avail of the benefit he obtained from the business. So, hindi siya matatanggal, maintain pa rin siya doon, pero yung capitalist partner have the right na kunin o mag-demand kung ano man yung kinita niya by venturing in that other business. So, in either case, the capitalist partner have the right to file an action for damages against the industrial partner. So, it is an act of damages Yan, nagkaroon ng liability on the part of the industrial partner kasi nilabag niya yung agreement or yung stipulations dun sa partnership. So, in addition to this case, capitalist partner can also file for damages against the industrial partner. Second topic naman is yung obligation ng capitalist partner to contribute additional capital. So, under Article 1791, so, there is no agreement to the if there is no agreement to the contrary in case of an imminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital, except an industrial partner to save the venture, shall be obliged to sell his interest to the other partners. So, ang general rule kasi, the capitalist partner, they are not required to contribute more than the amount that they are obliged to contribute. Pero if there is an existence of imminent loss to the business of the partnership, in that moment, the capitalist partner are compelled to contribute additional share to the partnership in order to save the business. So, yun yung pinapertains ng Article 1791. So kailan natitrigger ang Article 1791? So, kailan siya nagiging obliged? So, may mga requisites tayo. So, first requisite is, there is a imminent loss of the business of the partnership. So, because of that, kailangan mag-contribute kasi baka ma-default yung partnership. So, there is a compelling reason for the partners to contribute additional capital. So, may imminent loss dapat. Second is, the majority of the capitalist partners are the opinion that an additional contribution to the common fund would save the business. So, the capitalist partners nag-agree sila na mag-contribute para ma-save yung business nila, yung partnership nila. For the C, third is the capitalist partner refuses deliberately, not because of his financial inability to do so. So, kung mayroong isang partner na nag-refuse, kahit na mayroon siyang financial ability na mag-contribute, pero ayaw niya, nag-refuse siya, so, yun. Tas fourth is there is no agreement that even in the case of imminent loss of the business, the partners are not obliged to contribute. So, yung mga partners kasi, pwede silang maglagay sa articles of partnership na kapag nagkaroon ng imminent loss, they are not required to contribute additional capital. Pero, kung walang stipulations dun sa contrary or dun sa articles of partnership nila, pwede nilang gawin what the Article 1791 pertains or provides. For example, ngayon, kapag may capitalist partner na nag-refuse to contribute a additional capital, he will have an obligation to sell his interest to the other partners. Kasi by doing that action, by refusing to contribute additional capital, it shows na there is a lack of interest on his part to continue doing the business. So, it is noted that the industrial partner is exempted. So, note, si industrial partners is exempted from the requirement to contribute a additional share. So, having contributed his entire industry is enough. So, he can do nothing further. Our third topic is about obligation of managing partners who collects debt. So, under Article 1792, if a partner authorized to manage collects a demandable sum, so yung partner authorized to manage is the managing partner, which was owed to him in his own name from a person who owed the partnership another sum also demandable. The sum thus collected shall be applied to the credits in proportion to their amounts. Even though he may have been given a receipt for his own credit only, but should he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. The provision of these articles are understood to be without prejudice to the right granted to the debtor by Article 1252, but only if the personal credit of the partner should be more onerous to him. So, dito, if a person is separately indebted to the partnership and the managing partner at the same time. So, if yung isang tao is may utang siya sa managing partner, may utang din siya sa partnership at the same time. So, obligation of the managing partner who collects debt. So, there's a two scenarios kasi. Yung isa is yung debtor is magbabayad dun sa managing partner at yung isa naman if magbabayad siya dun sa partnership. So, sa first scenario is apply sum collected to two credits in proportion to their amount. So, if that person, yung debtor, decided to pay the managing partner. So, now, ang sabi kasi ng Article 1792, kapag ganito yung scenario, on the credit of managing partner, kung yung debtor is magbabayad sa managing partner, the managing partner is required na i-apply yung sum collected in proportion to their amounts. So, ibig sabihin, hindi buong matatanggap ni managing partner yung binayad sa kanya. So, ihahati niya yun in proportion to the amount na inutang din ng debtor dun sa partnership. Yung second scenario naman, so, if yung debtor is nagbayad sa partnership, sa credit ng partnership, so, if managing partner receive it for the account of partnership, the whole sum shall be applied to the partnership credit. So, lahat ng amount na is mapupunta doon sa partnership alone. Walang mapupunta kay managing partner. So, let's have an example para mas madali nating maintindihan. So, A and B are partners in AB company. So, C is indebted to A in the sum of 10,000. So, si C is the debtor. So, may utang siya kay partner A ng 10,000. So, C is also indebted to the partnership in the sum of 40,000. So, si C is may utang din kay partnership ng 40,000. So, both debts are demandable. So, if A collects the amount of 10,000 from C, so, ang na-collect ni A is amount of 10,000. So, if ang si debtor, if si C is ang binayadan niya is sa credit ni managing partner. So, if A issues a receipt to the effect that it is in payment of the A's credit, so, yung binayad ni debtor na si C is mahahati yan in proportion sa amount na inutang niya kay partnership at kay managing partner. So, kung 10,000 yun, mahati yun in proportion, di ba? So, ang 2,000 will be applied to the credit of managing partner, tas sa partnership being entitled to proportionate amount of 8,000 in the payment made by C. Pero sa second scenario naman, kapag si sa debtor, gives the receipt, yung si A gives the receipt for the account only of the partnership, yung whole amount nun, yung 10,000, will be fully applied to the partnership. Now, for this to happen, to trigger the Article 1792, may requisites din tayo dyan. So, first requisites is there exists at least two debts. So, first debt is dun sa managing partner, tapos yung second debt is dun sa partnership. So, may dalawang utang na nag-exist. So, yung debts na yon, second is demandable. So, both debts are demandable. And then, yung sa third is the partner who collects is the managing partner is authorized to manage and actually manage the partnership. Now, meron pang second paragraph sa 1792. So, under the second paragraph is the debtor is given the right to prefer payment of the credit of the partner. It should be more onerous to him in accordance with his right to the application of payment under Article 1252. Thank you.